This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are now joined by Todd Lutsky from the law firm of Cushing & Dolan. We call the segment Ask Todd because you get to ask Todd your questions. We've got the studio lines open at 888-205-2263. Todd Lutsky is here, and so again, this is your chance to ask him your questions about your estate plan or maybe your lack thereof, and hey, how do you get moving in the right direction? That phone number again is 888-205-2263. We almost got through everyone last week, but didn't quite. So, again, if you do have a question, get calling to make sure that you get an early spot in line here. That phone number, again, is 888-205-2263, and we'll get to your calls in just a little bit. Mr. Lutsky, how are you today?
I am never better, and you?
Things are looking up, actually.
Good.
I found a book yesterday, and it's called How to Solve 50% of Life's Problems.
Oh, yeah?
I bought 2.
That'll help. You're all set.
I figured I'd be good. So, Todd, I want to talk a little bit about Medicaid irrevocable trusts. And people hear the idea of, hey, there's this 5-year look back. Couple questions on that. Can you just define that term for people who aren't familiar with it? And the second question is, when does that look back period actually start?
Yeah, great point. A couple of things on the 5-year rule. Many people, I know you mentioned it in connection with the trust, Chuck, but I just want to clarify one thing before I define it. That some people think that, oh, well, if it's 5 years, if I put my assets into this irrevocable trust, I'll just give it to my kids instead. Well, the 5-year rule applies regardless of who you give it to. You could give it to your kids, which nothing good comes from that, never mind the fact that it takes 5 years to protect it from the nursing home. There's a lot of other negatives. But whether you give it to a child, whether you give it to a trust, whether the answer is that any time you take an asset and dispose of it and receive less than fair market value in exchange for what you did, then you made a disqualifying transfer, and that is the definition of what triggers the 5-year waiting period. So that's a disqualifying transfer. What is it? It means that if you've transferred that asset and received less than fair market value in exchange for that, then you get sick in the next 5 years and go to a nursing home, you'll be denied Medicaid benefits. It's that simple. It's a hard and fast stop. So if you're going to do your planning, try to think about, that's why we do it now, right? We do it when we're feeling good, not when we're not feeling good. And we can make the transfer and get beyond our 5-year waiting period. It has nothing to do with any other part of your estate plan. Your trust will still avoid probate, reduce estate taxes, provide a bloodline plan. You could die the next day. I jokingly, you say the dying part isn't the problem. That works immediately. It's only the nursing home that takes 5 years in order to get there. When does it start? It starts the day you create the trust, let's say, or the day you make the disqualifying transfer. But since I'm talking more about estate planning, let's focus on the trust. A client comes in and says, let's do Medicaid planning. I say, fine. I explain the whole process. We get started. They leaving the meeting. They'll say, okay, so did the 5-year clock start to run yet? No. When does it start to run? It starts to run the day they come back in after we review the documents and actually transfer the asset into the trust. They need to sign the document and fund the document. It's the funding of the trust that triggers the 5-year waiting period and the clock beginning to run. So hopefully that was a good definition all the way around.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you've got a question for Todd, this is your chance to ask him. Studio lines are open at 888-205-2263. Still got space for maybe one or two more people at most. Again, 888-205-2263. We're going to take a quick break here, but when we come back, it's right to your questions with Todd then. That phone number again is 888 205-2263, and we're taking your calls when we return.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
All right, we got some questions for you, Todd. Let's go first to Eric in Longmeadow. Eric, what's your question for Todd Lutsky?
Good morning, gentlemen. My question is, I'm in charge of a family member's trust. I'm the trustee of his trust.
Okay.
Now, I pay his bills, his credit card, and whatnot.
Uh-oh. I don't think we can hear him. So,
Hello?
yeah.
Tucker, why don't we put Eric on hold for a second and see if
Yeah,
we can get him back. And why don't we go instead to, let's go to Nancy in Norwood just while we get Eric back on the line there. Nancy, what's your question for Todd Lutsky?
Good morning. Thank you for taking my call. 15 years ago, my father died, and a year later, my mother signed the house over to me. We live together. I've been taking care of her, but I have 3 other siblings. What happens to the house when she passes away?
Well, you said, if I understand this, Nancy, you said that after your dad died, your mom gifted the entire house to you. Is that correct?
Right.
So only your name is on the deed?
Correct.
All right. So when you say what happens to the house after she dies, nothing, because she doesn't own it. Her estate doesn't own it. It's not part of her estate. It's a completed gift that she made to you years ago. I'm guessing she probably didn't file a gift tax return, not that it necessarily would have mattered. You now are the fee simple title holder to the property. So if it's been more than 5 years ago, it's protected from the nursing home. Unfortunately, you lost the step up in basis because she won't die owning it. And ultimately, you have no obligation to do anything with it when your mom dies. Now, if your mom's wishes are, I'd like to leave this to all three of my children, then, or however many children she has, then the answer is that's not going to happen unless you decide you wanted to honor that wish. But if you do, you simply will have to prepare a deed transferring the property to the other siblings, which will ultimately be a gift by you to them. And so technically it'll be a taxable gift because I'm sure it's going to exceed $18,000 per year per person. So in that case, you would need to file a gift tax return. But the good news is you have a $13 million gift tax exemption, $13.6 million gift tax exemption. So it shouldn't really matter from a estate tax standpoint for you, I don't think. I don't know the numbers. But it will eat into your Massachusetts $2 million estate tax exemption a little. So I don't love the idea that she gave it away, but she did. So it is what it is. And unfortunately, she does run the risk of potentially disinheriting her other children, as well as exposing it to your creditors and, of course, not even having the right to live there. But I know you'll take care of her and you won't kick her out. But these are all issues for the bigger listening audience, right? These are things that I don't love. I don't love it when houses are given away to children during life. I don't think anything good really comes from it. This is just a little example of it. But hope that helps, Nancy. And folks, one of the things you can do to prevent giving away your house, or instead of giving away your house while you're living, is learn about these Medicaid irrevocable trusts. The guide we're giving away is Unlocking the Power of Medicaid Irrevocable Trusts. In a very simple question and answer format, it will explain to you all the do's and don'ts of these trusts. And if you've ever thought these weren't right for you, or you weren't sure about how they work, or you're afraid of them, this guide will clear that up for you. I mean, it answers everything from what can I put in the trust? What are the gift tax consequences? Can I sell my house? Can I buy another one? What are the taxes if I sell my house? Can I live off the income? Can I manage my money? Folks, on and on. All the questions are answered in that question and answer format. Get the guide, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com, and do that rather than give away your house when you're living.
Let's go back to Eric in Longmeadow. I think we got some better sound now. Eric, what's your question for Todd?
How you doing? My father passed, and he put me in charge of his estate, and I'm the trustee of another family member.
Okay.
And charge that I pay all his bills and whatnot.
Mm-hmm.
Now, when the money runs out, and if he has any debt, am I on the hook for that?
So let me ask you this. You're saying your dad died, there's a trust in place, and there's a share inside Dad's trust of which you control that money for the benefit of your sibling, correct?
Yes.
And you actually use that money to pay some of his bills, to make distributions to him as he needs it, correct?
Correct.
So he never owns this money. He doesn't own this share. This share that's inside Dad's, now your late father's trust, isn't owned by him. So it's not even subject to his creditors. So if he has creditors, these assets are not subject to those creditors because this isn't his money. And no, you're absolutely not on the hook because it's not your money either. So, and you're not subject to his creditors. You're just trustee of a bucket of money that really, it's to take care of him, but he doesn't own it. So the quick answer is no, you're not on the hook as trustee of that trust if in fact this money runs out and he runs up creditor problems and bill problems, not your worry.
Todd, we've got another caller for you here. Let's go to Clyde in New Hampshire. Clyde, you are on with Todd Lutsky.
Hey, how you doing, Todd?
Good.
Quick question. Do a house have to be paid for before you put it into a trust?
So you're saying if you have a home and it's encumbered, you have a mortgage on it or a home equity line or something, correct?
Correct.
So if it's your primary residence and you have an equity line or a mortgage still outstanding on your home, when you want to put it into a Medicaid, I'm guessing one of these Medicaid irrevocable trusts. So I'll answer it both ways. One, if you want to put it into a revocable trust because that's the kind of planning you want to do, it does not matter. It's a revocable trust. You can put encumbered property in there anytime you want, and it will not trigger the due on sale clause. And that's what we're worried about, right? We're worried about transferring property and triggering the due on sale or the due on transfer clause that I'm going to venture to say exists in every mortgage, okay? Because remember, they lent the money to you, not to who you're giving it to. Okay, so revocable trust, no problem. Irrevocable trusts. If you want to transfer your primary residence to an irrevocable Medicaid trust and you have either a HELOC or you have a regular mortgage outstanding, you can still do it, but you need to reserve what is called a life estate. Now, many of you heard this term tossed around many times. A life estate is simply in the deed, it'll say, I hereby reserve a legal life estate in the property. What that means is you kept a little nugget of ownership. That nugget of ownership means you have the right to live there the rest of your life. You're entitled to collect all the income that property pays, and you got to pay the expenses. Hooray, right? That's part of being an owner. You're still deemed the present owner of the property because of that little nugget of ownership that you kept. And thereby, when you transfer it to the trust, you cannot trigger the due on sale clause because you did not transfer it, right? You kept a nugget that allows you to continue to live there. That nugget will also preserve that home equity line or that mortgage. So long-winded answer to yes, you can still do Medicaid planning even though your house has a mortgage on it.
Mr. Lutsky, thank you so much for joining us today. We appreciate it.
Always a pleasure. Thank you.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated. Elder life planning can be overwhelming, so make sure you're prepared, or you could make costly mistakes that affect your overall plan. Irrevocable trusts are the most common type of trust that folks use for financial protection. And while they can be complicated to create, they help keep your assets safe because they contain specific protections that many of us need, like the possibility of eliminating your estate taxes. Cushing & Dolan are experts in elder law and taxation, and they can devise a plan that covers you in every area where issues can arise. Their new guide is called Unlocking the Power of Irrevocable Medicaid Trusts. Learn more about how these trusts can benefit your family by calling 866-848-5699 right now. That's 866-848-5699. Or you can request the guide right now by visiting LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated.